Good afternoon, everybody, and welcome to this very special session, which is of great importance to us, definitely, as both as journalists and activists. So if it interests all of you also, very good. But we are going to be all ears for sure on a session like this. May I invite Mr. Mihir Desai on stage. Thank you so much, Mihir, for being here today. May I request Jamshed Mistry to greet Mihir with a bouquet of flowers. Arvind. So today's session is thanks to Advocate Jamshed Mistry, who has been saying that we need to have discussion sessions on issues, and this is jointly with the International Legal Alliance, which he's part of. I'm going to let Jamshed talk a little bit about the International Legal Alliance. Jamshed Mistry, as you know, is someone that a lot of us go to for advice as activists on all kinds of issues that he handles. He's been amicus curiae in several cases, and he's part of several of these networks, whether it's with Canadian lawyers or the International Legal Alliance or others that he has introduced us to from time to time, but I'm going to let him speak about it. More than anything else, he is also a special invitee on the Moneylife Foundation Board of Trustees. Before I ask Jamshed to speak, and then we go, this is the flow of the program. Jamshed is going to speak a little bit about the International Legal Alliance, and then he is going to be our key discussant at the session. We will have the talk by Sr Counsel Mihir Desai. Devashish is then going to show just a 5-point PPT on some important defamation cases that were useful to us in our fight with the National Stock Exchange. So before we go on to that, allow me to introduce Mr. Mihir Desai. We go back a long way. Once upon a time, we used to be co-trustees on Consumer Education and Research Center. I'm sure he's forgotten about it. Mihir Desai, as you know, is the go-to person for, I think, like Prashant Bhushan is in Delhi, and when it comes to the Supreme Court, when it is Bombay, it is Mihir Desai, and I'm sure he's overloaded with people wanting him to take up public causes, and he very generously takes them up all the time. He's been in practice for over 28 years. He's the founder member of the Human Rights Law Network, which is a network of advocates working on human rights issues across the country. They have offices in 21 states. He's also a member of the Justice Malimat Committee for drafting a syllabus on human rights degree, and he's a member of the drafting committee on housing policy in Maharashtra, Road Committee for Mumbai. He's also the author of several books, including subjects like Women in Law, Law and Minority Education, Institutions in India, Health Laws and Judgments in India. He's handled a number of criminal and civil cases concerning human rights violations in the Bombay High Court, Goa benches, Supreme Court. So human rights is something that he's passionate about, but even when it comes to Aadhaar or taking up tax issues, like I said, people rush to Mihir Desai for help. With these few words, I'm first going to invite Jamshed to speak about the International Legal Alliance and then hand over to Mihir Desai.
Good evening, friends. It's truly, remarkable that at this point of time, we know Moneylife Foundation. First, I became a member. Then I was invited on their board, and now since I have, founded a international legal alliance, basically, which is a network of lawyers internationally. We are all using the net to be virtual and to be in touch with each other. We started very small. We were just about 15 or 20 of us, and now we have at least one lawyer or law firm in, I think, 151 countries. We're not allowed to advertise, so a lot of people don't know about us, which is fine. The whole aim and objective is that you should be able to interact with colleagues not only within India, but even outside, and on a lot of these subjects, including the subject that we're going to talk about today. We have had very interesting discussions. I mean, I've been able to appear in matters outside of India which have a lot of relevance to what is happening today. So, and, thank you very much, Mihir, for making, you're able to come today and discuss this at a level, because I think today a lot of us, whether it's lawyers, journalists, activists, each one of us are faced with this ignominy of saying, if you go to court or you do something which is slightly out of the ordinary, you're sort of asked or you're threatened with the following. So I think, but it's very important for us to understand what all these subjects are and how we can actually defend it and defend it fearlessly. So may I request Mihir to... Thanks.
Thank you, Moneylife Foundation. Thanks, Jamshed. Moneylife Foundation especially is not a novice to defamation litigation. They face litigation and they've come out successfully from it, which is one of those few remarkable achievements in defamation law as far as activists go. But it has been it was an extremely, it's something from which we all learned the judgment and the way they went about handling the case. The two topics on which I am going to talk about today, defamation and contempt of court. These are the two topics. Basically, broadly, they are very vast topics, and it's very difficult to, discuss threadbare about them in the limited time that we have. But I will try to give a broad overview from the point of view of journalists and from the point of view of activists as to what do these laws say, and what are the things, how the judiciary has reacted to it, and what are the things one has to be cautious about, one has to be careful about, and one has to be careless about. So, we need to have a clear idea of what these laws are. Both these laws, whether you look at contempt or you look at defamation, are seen as an exception to the fundamental right of freedom of speech and expression. They are seen as an exception because Article 19, which talks of fundamental rights and fundamental right of speech and expression, there is an exception carved out that yes, everybody has freedom of speech and expression, but there are certain things in respect of which the government can make law to restrain that right. So security of state, law and order, etc. And defamation and contempt of court are specifically mentioned there. Now, let me first talk about defamation, because as they say that, what is defamation? In a common I think there is a lot of confusion about what is defamation. First thing we must understand is that if you abuse me in a private room, okay, when nobody else is there, you abuse me in the choicest of words, etc., etc., okay, it does not amount to defamation. Defamation is lowering the reputation of lowering the reputation of somebody in the eyes of another person. Okay, so abusing me in front of me doesn't amount to defamation, but abusing me in front of somebody else, okay, even whether I'm present or not, may amount to defamation, depending on what you're saying about what are the words used, what is the context, etc., etc. So a third person to whom this is communicated, whatever is the lowering of reputation, whatever words are used, okay, becomes very important in defamation, that there is a third person involved. Okay. The other thing which is important about defamation law is traditionally two kinds of defamations have been, defamation is divided in two kinds of defamations. One is slander and second is libel. Okay, written and oral and written. Okay, defamation. One is called slander, one is called libel. Okay? Also, if you look at the law, okay, the remedy for defamation, namely, suppose somebody defames me, what do I do? Right now, I'm talking from the point of view of the victim. Then we'll come to the point of view of journalists and activists, etc. But suppose somebody defames me, what do I do? Okay, legally. Okay, legally, I can either file a civil case, or I can file a criminal case, or I can file both. As far as civil cases go, for defamation, you can ask for damages, namely that I have been defamed, my reputation has been lowered, and therefore, okay, I need to be compensated in terms of money for so many lakhs or crores of rupees, etc. So that's one thing you can ask for. And the second thing the victim can ask for is that an injunction should be granted against that person, A, repeating what he or she has said in public, B, especially with the social media and all that, taking off. If it's oral, if I made an oral statement, then preventing me from repeating is fine. But if it's something written, if it comes in newspaper, you can injunct me from repeating it. But if it's on social media, suppose it's on a website, a web portal, something like that, then the injunction is also for removing that from the website. Okay, so you have three kinds of remedies basically within the civil law, which you talk about, that injunction, damages, and going back to the situation before the defamation occurred by taking off things from the media, etc., from the portal, etc. This is one thing. The second thing is the criminal one. Okay. Criminal defamation under section 499 500 of the Indian Penal Code, defamation is a crime. Okay. But it's a personal crime. Normally, the notion of crime is that the crime is against society. So what you do is you lodge a first information report in a police station, and then the state takes over the litigation. Suppose a theft is committed in your house. You are not prosecuting the case in court. It's the state which prosecutes case on your behalf, because it's supposed to be a crime against society. Criminal defamation, on the other hand, is looked at as a personal crime. So the state will not prosecute unless the allegations are against persons who are occupying positions in the state. Otherwise, in a private, you defame me, it's a criminal offense. But when I go to court, I file a private complaint. I don't lodge an FIR for the state to prosecute. Okay? So that's how, and the maximum punishment is 2 years imprisonment if you're found guilty. A lot of countries have done away with criminal defamation. A lot of countries feel that it should not be a criminal offense. Civil offense is fine, it's okay, but it's not something for which people should be put behind bars for defaming. A lot of countries have done away with criminal defamation. So cases were filed in Indian Supreme Court also very recently, some few years back. The main case was filed by Mr. Subramaniam Swamy, saying that criminal defamation as a criminal offense is unconstitutional and should be done away with. Yeah. But the Supreme Court did not agree, and Supreme Court said that within certain restricted sphere, criminal defamation as a criminal offense can continue on the law books and can be used against people. Now, the reason why many people have opposed defamation is, I'll just give you 2 or 3 examples of criminal and then civil defamation. There was a case, there was an article written in a Marathi paper concerning Swadhyay organization, which is run by I think Pandurang Shastri Athavle. Okay. Now that was a case which was where basically there were some remarks against Pandurang Shastri Athavle and one person called Didi. Okay, so there were very, very strong statements used in that case. Strong words used. No, I had thanks. Strong words used. Now, neither Didi nor Pandurang Shastri Athavle filed any case. Okay. Cases were filed by those who belong to the Swadhyay Parivar, as they call it. Okay. And about some 37 cases were filed. Because defamation, remember one thing, the reason why it can be used to harass is not just because somebody can file a case against you, but somebody can file a case anywhere in the country against you. For instance, if something comes in a newspaper, Times of India publishes something, I can say that I read it in Guwahati, though it pertains to my activities in Bombay, and I am in Bombay. Everybody is in Bombay. Somebody read it in Guwahati, so I have been defamed in Guwahati, so I'll go and file a case in Guwahati. Okay? So that is one reason why criminal defamation can be used to harass people. Okay? Because the case can be filed anywhere. Okay? The second thing is, and this was being done till this judgment came, but it is also being done now. But I'll tell you what happened here. So a lot of these Anuyayis of Swadhyay, the members of the Swadhyay Parivar filed cases across Maharashtra against this person who had written the article. But the High Court quashed these cases, saying that, look, defamation is a personal wrong. In the sense that, giving you an example, if you say that all lawyers are corrupt, okay, it won't amount to defamation, though it may be correct. Okay. What will amount to defamation is if you say that Mihir Desai is corrupt and you are not able to prove it. Okay. This is how the law works, that it is a personal wrong. So the High Court set aside these cases, criminal defamation cases, which were filed across board, and said that you cannot. Only Pandurang Shastri Athavle, if he felt he was defamed, or the Didi who felt she was defamed, could have filed cases. Other people can't say we have been defamed. Because Pandurang Shastri Athavle or Swadhyay has been defamed, because Swadhyay is not even a registered body or anything. So anybody can claim to be a member. Okay? So that was quashed. Similarly, just 3 days back, I had a case of a person called Anjali Damania. Now, Anjali Damania normally is active in various cases, including cases of disproportionate asset by ministers, etc., etc. So she had she has filed a PIL in which notices have been issued in respect of disproportionate assets of a ex-minister of the present government. Okay. She also took press conference. So 21 cases were filed against her in Maharashtra, and she was going on a Maharashtra Darshan because everybody issues processes, etc., etc., etc. And it's complete harassment. Okay? Everybody filed, the cases were filed in the name of the party at various places. Okay? So we approached the court. Right now it's at a nascent stage, but we managed to get a stay order, okay, saying that no coercive steps to be taken in respect of all these cases till such time as we hear the matter, etc., etc. The point I'm trying to make is that the criminal defamation, while now we don't have much of a choice in the sense that it has been upheld by the Supreme Court, is something which is used for harassing people quite a lot. It may have been used in genuine cases also, I'm sure, but a lot of it is being used for harassing people. Okay? Similar thing happened with the editor of Tehelka magazine, etc., who was also, who wrote an article in Delhi, sitting in Delhi, somebody somewhere in Sholapur, etc., filed case, another person filed case somewhere else, third person filed case somewhere else. So this is something which, has a chilling effect on people, because you write something and somebody's sensitivities get affected, and you may be able to prove yourself innocent at the end of the day. But remember, the courts in India, the process itself can really try and frustrate you out. Ultimately, you may win, you may lose, nothing may happen. That's a separate issue. But the process itself can be tiring out, and that is what happens with the criminal defamation process. Now, and remember one thing, that in criminal as well as in civil defamation, what is permitted and what is not, okay, is something which we have to be clear about. That you are permitted to write something, even say as a journalist or as an activist. You are permitted to write something, okay, and even criticize somebody, as long as it is seen as a fair comment. It doesn't have to be truth. It may be truth, it may not be truth. Okay? But it has to be a fair comment. It has to be a studied comment. You can come to your own conclusion and arrive at the decision and publish it. True, what you have to prove is justification, not truth. Okay? That I was justifying coming to this conclusion because of whatever I read. Second aspect about, so that's one thing, that fair comment. You also have to keep in mind now, with the privacy regiment, which is very, very strong, especially after Puthuswamy's judgment, where because on the one hand you have a right to privacy, on the other hand you have a right to publish something about somebody in press. Okay, so you have those two rights which compete in a sense with each other. Okay? Now, when you are talking about, so for instance, even if you write, suppose your next door neighbor is a sex worker. Okay? You may be truthful in publishing that she's a sex worker, but you need to show something more, that it was in public interest to bring this out. Otherwise, you are violating her right to privacy. Okay? So what happens is that it's not enough that you are, it's not necessarily that you are truthful, but it's also not enough that you are truthful. Okay? You have to be truthful, to the extent you can on the basis of this thing, but you can't go around going into people's bedrooms and writing things, okay, which have no relevance to public interest. Okay? So you have to, you can talk about issues. You see, a similar thing had happened in a case which is famously known. It's called Rangarajan's case, but it's famously known as Otto Shankar's case. Otto Shankar was undergoing life imprisonment, I think death sentence, for being a serial killer. Okay? And he wanted to publish a book and a series of articles, okay, on certain government servants, okay, and about their corruption or whatever other aspects. So there, the matter went up to Supreme Court because those government servants went to the court saying that don't allow him to publish. How can he publish about what we are doing, what we are saying, etc., etc. And the Supreme Court laid down the law that ordinarily, okay, what I do in my bedroom or what I do in my house is my concern. Okay? And people cannot write about it without my consent. But otherwise, the press has the full freedom to write what they want. Okay? With the exception of women who are subjected to rape, molestation, their names cannot be published. Okay? That's one aspect. Second thing is, while you cannot write anything about what is happening in my bedroom, etc., okay, once something becomes part of public record, whether it's a court case, whether it's something, some other public record, then you cannot be prevented from writing about it. Okay? Whether it deals with private matters or non-private matters. Okay? So suppose a matrimonial case is going on in court. Till it reaches the court, you can't really write about the matrimonial disputes which are happening. But once it becomes, suppose an FIR is lodged, then it becomes an official public record. Suppose a case is filed, it becomes an official public record. Then you can write about it. Okay, I mean, broadly speaking. Even then you have to represent truthfully what the record says and all that. But then you are not prevented from writing about it. This Supreme Court in the same judgment further says, but there is an exception. The exception being, as far as public servants go, government officials, okay? Government officials, if they have done something connected to the discharge of their duty or related to the discharge of their duty. Related means if you take money, it's related to the discharge. It's not necessarily connected. It may be connected also, okay, to the discharge of the duty. Then they cannot sue anybody for defamation if somebody writes about it. Okay? They cannot prevent publication if somebody writes about it. Okay? As long as it's fair and accurate, etc., etc. Okay? So broadly speaking, the newspapers are given quite a broad mandate to write. 2 or 3 things which they have to be careful about is, if you are writing about an issue, if you are making allegation against a person, okay, you also should try to take that person's opinion as to where, I mean, this is the allegation against you, what do you have anything? You will see it in normal newspaper articles. It is written that we tried to connect the person but he refused to respond, full stop. You know, that kind of thing happens. So that is one thing which you have to do, that you try to connect the other, try to contact the other person and see if that person has any view on this, and then also publish those views. Okay? But broadly speaking, freedom of speech is quite broad. The court also says that there cannot be a pre-censorship on media. See, on films there is pre-censorship. That is, a film before it is published, before it is shown, has to undergo censorship process. That was challenged in K. Abbas's case and some other cases, that how can you have pre-censorship? Where the court made distinction between, say, newspapers and films. And basically said that films can be censored. Similarly, theatre, the script has to be censored, passed through the censor, it has to be approved, and only then you can publish you can perform a play in public, etc., etc. But for press and for other writings, okay, there is no pre-censorship, just like on internet. Okay, there is no pre-censorship. Okay? You have a lot of cases which are filed, say, and nowadays it happens very often in courts, which are filed against, say, Google or Facebook or some of the others, saying, take this down, this is defaming, why are you not doing this, etc., etc. And those battles are going on. Okay? As to what is the responsibility of the platforms which are on the internet. What is it? I mean, can YouTube censor what it is putting up? Can Facebook remove something? Okay, or is it violating freedom of speech and expression? So these issues are still being debated in courts. Many times the courts have been granting injunction. Many times we have seen Facebook or Google and all will say, come and say that yes, this is something offending, we are taking it off. Okay, so these things happen. Okay. The other aspect which I just wanted to mention about defamation is the civil defamation and use of it or misuse of it for, again, bringing about a chilling effect on persons who are critical of A, B, or C things. A lot of this happens, I've seen, at least my experience is that a lot of it happens in terms of many big corporate houses, okay, going to courts and seeking injunctions, okay, against articles which may be critical of them. And unfortunately, the Bombay High Court is somebody which is very, very eager to grant injunctions. So even if anything happens anywhere in the country, okay, except for Gautam's judgment, generally anything happens anywhere, okay, people come to Bombay High Court and file a case here because the likelihood of getting an injunction against publication is much higher in Bombay High Court than anywhere else. The reason is very simple. You see, there is a British law which India follows, because tort law, civil law is the tort law, which is not a legislated law. It is a common law which you have been following since British times. Yeah? And so you basically get inspired by the British, what is happening in British courts, etc. So British courts have said very clearly that if an article is defamatory, and somebody comes to court saying grant an injunction against this person from publishing that article, okay, and if the person who has written that article says that I'll justify what I'm saying in this article, okay, I'll justify what I'm writing in this article, then no injunction can be granted. Okay? Justification is a complete defense to a plea of injunction in this thing, British courts. You can always claim damages. Ultimately, if you win, you will get your damages. You lose, you don't get damages, etc., etc. Case goes on. But injunction, stopping you immediately, okay, that doesn't happen. This is the law followed by all courts in India except Bombay High Court. Okay? Like, for instance, in Delhi High Court, there was a case filed by Tatas against Greenpeace, who were talking about some plant of Tata's affecting Ridley turtles, Orissa beach somewhere. And for that, there used to be, those of who are of my age who remember, there used to be a game called Pac-Man on a computer, which some small animal goes and eats up everything. Okay, so they showed Tata's as that Pac-Man going and eating up Ridley turtles, kind of. That was a game which they software game which they came out with. Okay, now they went to Delhi High Court. And Greenpeace said, we'll prove that what we are saying about their plant affecting Ridley turtles is something which, what we are saying is correct. We'll justify our allegation that their plant, because of the effluent which comes out, etc., etc., is causing Ridley turtles to die. Okay? So once that was done, once they said justification, Delhi High Court said, sorry, no injunction. We are not giving you injunction. If you win, you will get your damages. Otherwise, forget about it. Okay. But as I said, that in Bombay High Court, the situation is quite different. So you will see every second day in Bombay High Court nowadays applications being made for injunction, even against things which are not published. Yeah. I do represent Times in a few cases, so I know, because you get these defamation cases against Times of India or many of the newspapers saying that you are, injunct this article from being published. Or now with web pages, I mean, everything goes on the web. So it's also that you take off the thing from the. So this is very, very this thing. There is another organization called Crop Care Foundation. Now this Crop Care Foundation is supposed to represent the fertilizer lobby. Okay. This foundation has a habit of fighting either itself or through United Phosphorus Company, okay, cases against anybody who does even a mild criticism. If I say fertilizers, well, they may be harmful, then they'll file a case against me for 100 crores in Valsad court or somewhere else. Okay. Now this is something which is very regularly happening. Okay, they file cases. Finally, one of the cases went to Supreme Court, and Supreme Court said that this is rubbish. You can't file cases. Somebody is criticizing, somebody doesn't agree that fertilizers should be used. Somebody feels that organic farming should be used, okay, or less fertilizers should be used. You can't sue them for defamation. Okay? This is a debate which should go on. Okay, you can't sue people for because the whole idea is you harass people so much. See, there are these the small NGOs, etc., which work on issues. Okay? Now, if you work on those issues, okay, somebody will come and file a case against you, a big corporate, makes you run around. Finally, you will say, there are many other issues. Let's take up some other issue. Isko chodo. And you stop talking about it. But the essential thing is it has a chilling effect on the kind of things you want to do. So that's one aspect. The second aspect is that as far as even activists are concerned, the courts have consistently held that when you are talking about, see, you use in a lot of places, words like so-and-so Murdabad, so-and-so this, so-and-so that, That doesn't, Murdabad means basically death to somebody. Okay? Now people sue saying, ye bol raha hai, mere ko maar dalo. Mujhe Murdabad bola. So, defamation. Mera naam badnaam kiya, whatever. The courts have said that in activists, organizations which are based on campaigns, etc., okay, some amount of embellishment, some amount of, pejorative writing or speaking, okay, it doesn't become an incitement. Doesn't become. It's a part of a culture of organizations talking. The same thing had happened to McDonald's in UK. For instance, in UK, there was some group of people who were saying that Mac burgers are harmful to health, and they were distributing circulars, etc., pamphlets. They were taken all the way up to European court, okay, saying that this is harmful, etc. How can they say it's harmful, etc.? Where is the scientific certainty that it's harmful, etc.? It's like saying, where is the scientific certainty that tobacco causes cancer? Because nobody yet knows what causes cancer. So how can you say tobacco causes cancer? That kind of a debate. Okay? So, but the courts have basically said that you can't stop this kind of debates and this kind of opinions to be expressed. Okay? So, broadly speaking, as far as defamation is concerned, 2 or 3 things which we have to be clear about is that as long as one is talking broadly by doing, it's not, you can't keep on abusing people. Okay? But if you're analyzing a situation, you're talking about a situation on the bench, and that Justice Gautam Patel's judgment in Moneylife's case is an excellent example of how, what the law is and how it should be interpreted, more so. Yeah. Because, we will be talking a bit about it. Okay. So I will not talk about it, but it's an excellent example of that.
No, but you can talk on the judgment. I'll be talking about only the cases that I referred to, which is Reynolds and all that.
Okay. Reynolds versus Rylance versus Fletcher. Okay. See, basically, as Justice Patel himself says in his judgment time and again, that it's too technical for a judicial mind to understand what you have written. Okay, in the sense that it was about certain in a very simple language. It was about certain insider trading of certain kind. What is it called? Yes. I think you better only talk about it because I'm getting. So Justice Patel basically said that, look, they have actually Moneylife had both of them had the plea of justification. They said that we are justified in doing writing what we wrote. Now the court goes into it. Okay? Court goes into it. The judge goes into it, finds that they were justified in saying what they say, and also finds that it's not this thing. What do you call it? As far as the plaintiffs were concerned, in that case, stock exchange, okay? National Stock Exchange, that they were maliciously coming after them and directed them to pay 50 lakh rupees. okay, as damages. The plaintiffs were directed to pay 50 lakh rupees as damages, and finally they went in appeal, but they withdrew. Finally, everything was, and they withdrew the case. So, they paid, yeah. So, yeah. It's a great thing which happened. I mean, it's one of the best judgments you can find, and credit to them for having pursued it on their own, not through lawyers. Okay, which is something which is at least in court, right? So it is an excellent judgment, which shows that if you follow the normal principles of journalism, ethical journalism, okay, which is studying what you are writing, doing some research on what you are writing, trying to find out what the other side's opinion is, doesn't give the opinion, fine, you can't help it, and then reporting it. Even if a case is filed against you, the chances of that person succeeding are very bleak. That's the point. That as long as you are on sure footing, okay, yes, there can be some harassment, there can be some irritation, etc. But as long as you are on sure footing, I don't think one should worry too much about defamation. Provided one is on sure footing and one doesn't use abuses, one uses a temperate language, okay, in writing what one writes, then while it is an irritant, while it can be, but that irritation part can be taken care of, like it has been taken care of when 10 cases or 20 cases were filed by courts granting injunction, etc. So that is something which we need to keep in mind. I just wanted to go to the second issue, that is the contempt of court. Yeah, sure.
So, criminal defamation.
Sorry, 1 second. I'm going to request everyone to use a mic because we are recording it and it's also on Facebook. So people won't be able to hear you unless you take a mic.
Okay,
No, it's not a.
Okay, I understand. So, as I understand,
Yeah.
the criminal defamation can be only against a person, not an organization.
No, organization can.
Criminal defamation.
But yeah, I'll come to that.
Okay.
I'll explain to you.
Okay, but civil defamation can be against an
No,
organization.
you are talking about
also.
against or by?
Against. No, by. Sorry, by.
You are talking about by. No, see, criminal defamation, in fact, the section 499 of section 500 itself, 499 itself says that criminal defamation can be even by an organization. Okay. But that has to be some kind of a registered organization. So a company can say, I have been defamed.
Okay.
But Swadhyay Parivar is too loose a body.
Okay.
But they can't say we have been defamed.
Fine, understood.
There has to be some legal entity which can say that I have been defamed.
Right.
Okay, but not some loose body of people who say that we follow this and we follow that kind of thing.
Clear.
Okay? That's all.
Yeah, thank you.
I'll talk about contempt a little bit. See, contempt basically is again of two kinds: civil and criminal. What most of us here would be concerned with is criminal contempt, and the reason is this: that civil contempt is essentially if an order is passed against a person X, and that person X violates that order. An injunction is passed against you saying you can't enter this premises, and you still enter the premises. Then you have, by violating a specific order of court, you are committing contempt. An order directed at you, okay, you are committing contempt of court if you violate that order after having known that such an order is passed. Okay, so that's civil contempt, which you may face only if you are already in a litigation and some orders are passed against you and you violate that order. That's what civil contempt is. But unlike what the term suggests, the punishment for civil contempt is criminal. Okay, so you go to jail if the court wants you to go to jail. Okay? Otherwise, no. But the point is that though it's called civil contempt, okay, the punishment is still criminal under the criminal law. Okay, the criminal contempt is basically abuse of the process of law. court, you have read about 2 days back that one lawyer, was punished for criminal contempt by the Supreme Court by saying that for 1 year you are debarred from coming here. That's under the powers of criminal contempt. Now, criminal contempt can arise in various kind of situations. Like the first instance I remember in my personal life as a professional, was I was a new young lawyer. I was arguing before a judge, Justice Arvind Sawant, who was also before that the Advocate General and all. And I was arguing, and suddenly I see something going past me and past the judge and hit the wall, and it was a sandal. And first thing I wanted to say was, no, I have not done it. I have, that kind of thing. Not my client. It was somebody else who felt aggrieved by some order, of the court, and threw a sandal at the judge. Now that amounts to criminal contempt, that you are abusing the process of courts. You are basically sullying the clean waters of justice, as they call it, etc., etc. I mean, one need not get too much carried away by that, but that's what contempt is. That is what criminal contempt is. Now, two things you must remember. First, and this is something which I get asked even by journalists. Most of the journalists know about it, but I'll still say it, that there is no contempt if you even stridently criticize a judgment of even the Supreme Court full bench. Let me be very clear. If you say that Supreme Court was wrong in giving this judgment and wrong for A, B, C, D reasons, it does not amount to contempt of court. Civil, criminal, whatever. You are free to say that. In fact, yesterday only, I was arguing a matter before the division bench here in Bombay High Court, and we were discussing a Supreme Court judgment, whether it applies or doesn't apply. So I told the judge, this is the only thing in which the bar is in a better position than the bench, because we can criticize the Supreme Court judgment, you cannot. So, so anybody can criticize a Supreme Court judgment on merits. That it is a wrong judgment. Say yesterday there was a discussion on Aadhaar. There is a judgment on Aadhaar. So you can criticize, saying that it's a wrong judgment. And you see these criticisms coming repeatedly on, even in media, say triple talaq judgment, various other judgments which are very hot, Sabrimala judgment, various sensitive matters. You can criticize it no matter how stridently you want to criticize, you can do that. But you can't criticize the motives of a judge. That amounts to contempt. You can't say the judgment was given by this person because he took money. And remember, even if you have proof that he took money, you can't do that. Even that amounts to contempt. Now, this is something which you have to bear in mind. So, criticize the judgment. If you don't want to commit, there are some people who will say, doesn't matter, I'll commit contempt, but I'll say this. But by and large, criticize the judgment, criticize the conduct. No problems. That doesn't amount to contempt. But criticizing the motives of a judge, or attributing certain reasons why a judgment was given which are not on merits but on something else. That it may not be corruption, it may be caste, it may be communalism, it may be any issue. But attributing to a judge motives will amount to contempt of court. So that's something which, now again, the criminal contempt jurisdiction in a number of countries has been done away with. Many countries say that criminal judges don't need defense of contempt. They can defend themselves otherwise. You don't need to defend yourself. So if somebody throws a chappal at me anyway, it's an assault. That person can be prosecuted for assault. You don't need criminal contempt power in order to do this, because criminal contempt, a lot of people say, can tend to be abused, can tend to be can tend to chill. Because even if I have proof, if I am unable to show that, unable to prove, unable to bring forth the proof about, and let us be clear, because even Supreme Court judges have said that that there is substantial corruption even within judiciary. Okay, so that's a fact. Okay, and if I am unable to bring that out, if I am unable to talk about that in public, then especially if I have proof, etc. And looking at the way in which the judiciary is constituted today, namely they appoint themselves, they transfer themselves, they are not subject to Right to Information Act, they are not subject to various other laws, etc., etc. So you have a complete opacity in appointments, in transfers, complete non-accountability in various other ways. Okay? Now, why should this criminal contempt at all be there on the and especially if you have, they amended the law. Okay? They amended the law, the criminal contempt part, to mean that now you can't prosecute a person if he is able to prove that a judge is corrupt. Okay. But that has been interpreted by Delhi High Court again to mean that no, but you still can't criticize the motives of a judge. So this is the interpretation that is now pending in the Supreme Court. But so the situation today, as of now, is that you cannot criticize the motives, the biases, etc., etc. of the judges. That will amount to criminal contempt. Okay? And criminal contempt is what you have to be cautious about. So when you write, or when activists and activists suffer. I mean, you have seen Arundhati Roy being tried for criminal contempt, Prashant Bhushan himself being tried for criminal contempt. Okay, many times what happens is, and this is how it works out in courts normally. Okay, doesn't always work out. Normally, what happens is that you write something, you cast some aspersions, or during the arguments you say something to the judge. Okay, some lawyers who have very abrasive and can say something to the judge individually. And then criminal case is filed, criminal contempt is filed. Then the lawyer writes an affidavit saying, I apologize unconditionally. Okay? Then that apology is accepted and the matter is put at rest. This is how the normal thing works out. Okay? Sometimes it doesn't. Like it didn't work out in Justice Kannan's case, who was a judge of the Chennai High Court and then transferred to Calcutta, and who made very, very strong allegations against Supreme Court judges, some of which I personally don't think, I think he went much overboard than what he could have done, what he should have done. But anyway, so, and then he was punished for contempt, put behind bars for 6 months, as you know. He was the first sitting judge to be put behind bars for 6 months, so, or sitting or retired, I guess, to be put behind bars for 6 months for contempt. Similarly, day before yesterday, you had a lawyer who was. You see, the powers of Supreme Court are quite wide. So while the contempt of court may prescribe a particular punishment, the court may not give that punishment. Court may do something else, like they did with this particular lawyer. They said that we are punishing you for contempt, but what we are doing is the punishment will be you won't be able to practice for 1 year in Supreme Court, and we are sentencing you for 3 months imprisonment, but that's a suspended sentence, and that sentence will trigger out only when if you continue to browbeat judges. The allegation was that he browbeats judges in the courts. Okay, so if you continue to browbeat, then you will be put into, but if you behave yourself, you won't be put behind. So that's the kind of judgment. So in contempt, this is the basic thing which you have to be, and certain other things which may amount to contempt, like publishing the name of a woman victim of rape, okay, in newspapers, okay, may be treated as contempt. Because there are specific laws which say you can't do that. Okay, so these are the kind of things which you have. I mean, as activists also, one has to be cautious about. Okay, and as journalists, that you don't get into personal vilification. You criticize the judgment, you criticize, say, conduct. That's why there is a demand now that everything which happens in court should be videographed or should be telecast, or whatever, if it's because we are in a, like there was this one case which we handled. There is this famous case of Sohrabuddin, which was going on, which was transferred from Gujarat to Bombay, and it was going on in Sessions Court. And then one fine day the judge said that the media will not be allowed inside. Media cannot write about it at all. Okay, there was a complete gag on the media. And then we had taken it to the High Court. And the High Court removed that gag. Right? Basically saying that, look, in India the trials are supposed to be open trials. Okay? That is, anybody can come in and anybody can report about it. What is happening? The whole idea of a democracy is not to have secret trials. Okay? Let people know what is happening in all institutions, including courts. That's the whole fulcrum of democracy. So you can't prevent media unless there are certain very, very sensitive issues like for instance, this case of Bal Thakre's will was going on in court. And Jaidev Thakre came and wanted to say that, wanted to make some personal allegations basically. Okay? And he wanted to lead evidence for that. So then the judge said that this can lead to kind of law and order situation. You better say it in the camera. Gautam Patel again. Yeah. So that is a specific kind of a situation where the courts do have powers to conduct in-camera trials. Yeah. But if it's not an in-camera trial, and you can't generally conduct in-camera trials, okay? Sometimes in matrimonial disputes you have in-camera trials. POXO cases about children being sexually molested, etc. You have in-camera trials. Their names can't be revealed and all that. But otherwise, trials are open trials where media is allowed. Media can write about what is happening in the trials, what is happening in court, and there cannot be a restriction on the media. And so if you write something which is happening in court, it cannot amount to contempt. At the same time, they say, and this is something which is, you see, it can swing either ways, in the sense that at the same time they say that media trials are to be avoided. Yeah. Namely, you can't have a trial, you can't have somebody convicted by the media before that person is even tried. Yeah. Many times it happens that somebody is placed before the media, okay, they confess kiya hai, crime, okay, before even the trial begins. Okay, now those kind of things are not, because ultimately whether you are guilty or not is to be decided by the courts. And so those kind of things are treated as contempt sometimes, criminal contempt. That you try and, prove. Normally the criminal contempt is not filed in these cases, but sometimes there are a few examples of them being filed. Otherwise, what you have is that the courts keep, on the one hand, the courts say that media trials should not be conducted because media is convicting somebody, and judges are also human beings, they get affected. They watch. There was a judge in the US Supreme Court in the 20s who said the day I became the judge, I stopped reading media, I stopped talking to my wife about anything outside the house because I should not be affected by what is happening elsewhere. But obviously you can't expect judges to be like that. I mean, they watch the TVs, they watch they read the newspaper, etc. So that's one thing that ultimately it indirectly influences judges. On the other hand, they say many times that no, judiciary we are too strong to get influenced by these media things. So it doesn't really worry us, So you have both kinds of arguments going, and judgments reflecting both kinds of arguments in court. But essentially, okay, a media trial can be construed at times, and has been construed at times by the courts as bordering on contempt. So that is the other thing which one has to be a little cautious about, though much more is about, criminal contempt is used much more for conduct of people against individual judges. Okay, that's what happens. That against individual judges, either inside the courtroom or outside, okay, that criminal contempt is used. So basically, making allegations saying that 50% of the judges in India are corrupt will not amount to either contempt or defamation. But saying that this particular judge is corrupt will amount to criminal contempt. Okay, so one has to be cautious about that. Okay, that's all. Thank you very much. I think I'll stop there.
Asked to just present what we did in case of, I'll do that. What we did in our particular case. So we can only talk of what the processes we followed and the case laws that we referred to. We were helped in this by none other than Subramaniam Swamy, who has this great record of having won, he says, every single defamation case that he has filed, and not having lost any. So he, while going to the airport, I was mailing him and he was replying to me. So I asked him which are the case laws, because we had to prepare it for ourselves. We didn't have lawyers in the first round, which is when it was actually heard and when the judgment was delivered. It's only in the division bench that we had the benefit of having, good lawyers for us. By which time, of course, the judgment had come, and most of the case was won. There was no injunction against us, and we could write, and so on. Everything was over in a matter of 6 weeks. I think the first notice of motion came up on 24th July, and 9th September was this great Gautam Patel's judgment, which actually was a big talk of the legal circles in High Court. Large number of them hated this judgment because who is this, 2-3 people coming in and standing there and making some arguments, and Gautam Patel giving this brilliant judgment, which can be now quoted everywhere, because finally that's what stands, because they withdrew the case. So this is one of the first things that we cited, and the key thing here is that the investigation was being pursued with diligence. In fact, there's no evidence that there had been any investigation. So his writing in this particular case was entirely in public interest. That's one of the points that Mr. Desai has made. So the first criteria is that, are you writing with an agenda? Are you writing for the public? Is it supposed to benefit a large number of people? This is one of the first things that the courts are going to decide. In fact, I will mention later that these things can't be attached post facto. You can't write anything and then go and sort of argue that it is in public interest. Your work itself should be done in a manner that you're doing more public interest and not the other way around. This was one of the most cornerstone judgments in 1994, which is R. Rajgopal versus State of Tamil Nadu, Justice Jeevan Reddy of the Supreme Court. The most crucial thing in this is that in such a case, it would be enough for the defendant, that is a member of the press or media, to prove that he acted after reasonable verification of the fact. It is not necessary for him to prove what he's written is true. So everybody will tell you truth is your strongest defense. You have to stand up and say that, yes, I know what I've written, it's a fact. But in this particular case, in case of public officials, where you're writing about something which involves public officials, this is a very, very important thing that was held, and he acted after a reasonable verification of the facts. Once again, it is in the process of the work that you do, in the principles of journalism that you follow, that through which you are able to fight, and these things can't be done post facto. Reynolds versus Times newspaper. Two most important things, and I'm going to elaborate on this in the subsequent slide. Once again, it was in public interest that the information should be published, and the publisher has acted responsibly in doing so. Now, everybody is going to ask, what is public interest? Of course, that's why the courts are there. You have to prove, and through long processes of work and judgments, etc. It's been very fairly established what is in public interest and what is not. Acted responsibly, fortunately, in my next slide, is a very clear articulation of what is responsible journalism, and for this we refer to Lord Nichols of Birkenhead, and these are the factors that he says, about 10 factors which is the real test of whether the newspaper or the publisher has acted responsibly or not. The seriousness of the allegation. It's not something frivolous, it's not something small. Once again, if it's in larger public interest, it's serious enough. The nature of the information and the extent to which the subject matter of public concern, the source of the information. Some informants have no direct knowledge. Some people have their own access to grind. So who is your source? Where have you sourced it from? Have you verified it? Have you checked it? And so on. The steps taken, once again, a process. Before writing, what did you do? What are the steps that you took to verify the information? The status of the information allegations may have already been the subject of an investigation, which is very important. All of these things are very important in our particular case. Already Virappa Moily was asking for an investigation into the algo scam of NSE, right? The urgency of the matter, news is often a perishable commodity, therefore I had to write. I couldn't wait for X, Y, Z, and so on and so forth, otherwise the news would be stale. When a comment was sought from the other side, this is absolutely the cornerstone. You just cannot go out and write whatever you want to without giving a reasonable opportunity to the other side to defend their case, to defend their position. Whether the article contained the gist of the other side, and having asked, you have to incorporate that. The tone of the article, whether it's reasonable, whether it's shrill, whether it entices people to do something wrong. No. The circumstances of the publication, including the timing, why are you writing now? Now, if you just go back to each one of these, our particular case, when we stood there and argued, we can check box in each of these. It was serious, it was in public interest, we had taken enough of steps to verify, we had asked the other side not once but thrice, and we could produce the SMSs that Sucheta had sent to them. And the fact that the tone of the article was not, we didn't allege any wrongdoing. We said there should be an investigation. In fact, that's the main point that Nichols Birkenhead says, that can raise call for an investigation. It need not adopt allegations as statements of fact. We didn't do that. And the circumstances, including the timing, because we waited, we asked, and if we did not publish, nobody else was writing, we were the first, and so on and so forth. Now, I want to make a very specific point here, and that is that I am not aware of any publication. I've worked in so many of them. I worked in Business India, Business World, Financial Express, Times of India, and Business Today, where I did the first cover story. We launched the publication, and a couple of them which are defunct now also. So I do not remember, till the time I was journalist, which is 84 to 94, a full-time journalist, I do not remember a single case in any of these publications where these things were told to me either before I joined, during I joined, or whenever I did a story, right? So the publications themselves make themselves vulnerable by not following these well-articulated, clearly laid out steps and incorporating it in their processes. Now, this is an essential flaw of journalism, at least the way it's practiced in India today, that first of all, people who are not trained or qualified, they come into this. So, it will be extraordinary to find a civil engineer, somebody who's not a civil engineer, to be building bridges. But here there are people who possibly have no training, or not been trained in-house, out-house, wherever. They're sent out out there and to write a story, and there are probably no checks and balances, and they themselves become very vulnerable. I also want to point out that in our case, in our specific case, not only was that this article was written by Sucheta, who had a formal training in journalism, but I have noticed in my 30 years that in all of these things, whether she's aware of this or not, all these are incorporated in every article that she writes. So it's part of her process, and that's what makes her one of the best in the country.
I studied law.
Oh, you studied law as well. Well, it becomes a part of her process. It's part of her blood. So it's if your work process is strong enough and you followed all of these things, you have nothing to worry about. You can always count on somebody like Mihir Desai to defend you when he sees the fact reacts to the case and he says, yes, you've done all the right things and you have a case here. If you don't have a case here, then of course that's another matter. This is a very, very famous case, which is New York Times versus Sullivan. Doesn't fully apply over here, but this is how, advanced countries, well-developed countries see their press and the kind of the freedom that they gives in. So it says, the judge, it's a little roundabout way of saying it, but he says that if you compel the press when they are writing about public officials, or when they're writing about public figures, to guarantee the truth, that yes, you cannot write unless you guarantee the truth, that means self-censorship. You cannot have that kind of a situation. So the courts have recognized the difficulties of adducing legal proofs that will pass under the strict eyes of the judge, and under such a rule, would-be critics of official conduct may be deterred from voicing the criticism. All right? So you cannot have a law, you cannot have a system where public officials cannot be criticized because you cannot bring the strictest possible legal proof to the court. So you have to have that level of freedom. This is how it was held. It's really a landmark case, New York Times versus Sullivan. These are the two slides which are related, now this is a new thing that's come, and Mr. Desai would know all about this. This is not my domain, but Sucheta mentioned that this should be part of this thing. So this is a very peculiar new thing that has come up, which is strategic lawsuit against public participation, mainly aimed at NGOs. All right? So this is nothing other than a lawsuit that is intended to censor, intimidate, and silence critics by burdening them with the cost of illegal defense. In a slap suit, the plaintiff does not expect to win. Their goals accomplished if the defendant succumbs to fear, intimidation, mounting legal costs, or simple exhaustion, and abandons the criticism. Okay? In some cases, repeated frivolous litigation against a defendant may impose financial costs and so on. A slap may also, it's a message to the rest of them that don't go after us, this is what we are going to do to you. Now, the most extraordinary thing is what Professor Sridhar Acharyulu, who was one of the election commission, information commissioners, and he said that CIC itself and the citizens are a target of slaps. Unfortunately, the government bodies, they themselves are doing this, slapping writ petitions right, left, and center against respondent 1, which is a CIC, and number 2, the citizen who are asking for information is empowered by RTI. Government officers want their rights to be protected from the Information Commission as per the will of the Parliament of India, which means that the government itself is a major initiator, according to Professor Acharyulu, of slap suits. So this is just... Oh boy, 1700 writ petitions, yes. So this is a short thing that I wanted to share with you, and how we went about, what cases we relied on. And once again, I conclude by saying you cannot write what you want to and then look for case laws to defend you. Your processes have to rely on what is legally tenable, and that is very clear. A little bit of Googling can tell you what is the framework in which you work, and if you incorporate that in your work process, you have nothing to fear. Thank you very much.
Thanks, Vishesh. May I now ask Jamshed to say a few words, and I think may I request both of you to come.
So I think we've all been, very, very ably educated by both the gentlemen, Mr. Basu and Mr. Desai. And I actually want to, start. Mihir has covered certain very, very interesting subjects. Now, for example, and let me start by asking you on two aspects. One is prior to that, our Contempt of Courts Act was actually amended to include truth and public interest as a defense a while ago. That is one. The second aspect is in regard to defamation. In your experience, how first and foremost, with the courts not really awarding damages, and for example in Moneylife's case it was damages in reverse, more as costs. Have you really seen sort of the trends you made a case in point that the Bombay High Court was exceptional, but have you actually seen that increasing? For example, awarding costs in arbitration has gone up tremendously, but have you really seen the ultimate damages and or costs, that aspect which is a part of tort law, has that really changed, or is it likely to change?
Coming to the second question first, see, the suing for damages for defamation is something which is not, I guess it's just 15 to 20 years old in India, because it is not, before that, at least when I started practicing, I wasn't seeing anybody being, any NGOs or any, and there were cases like Rekha suing Stardust or something like that, but you wouldn't get these kind of defamation cases happening, civil defamation cases. So it's only 15 to 20 years that these civil defamation cases are started. So looking at the speed at which the courts move, the first of those cases has yet to be decided. Okay, so in terms of most of these cases get settled somewhere down the line. Okay, the idea of a defamation case generally, as he mentioned, is it's a slap suit. Okay, the idea is not to win damages. Idea is to stop that person from writing something which might have immediate effect. Okay, so that's the basic purpose of these kind of suits. Of course, that doesn't mean they'll withdraw each and every case, etc., etc. But it so happens that it runs out of steam. Lawyers then don't come. Once you got injunction, and once that period, that acute period when you were worried about something coming against you, that period has gone. Okay, then really even the plaintiffs I've seen in many cases not bothering. Okay, about doing anything. Like this very case judgment which is referred to in your judgment, that is Maheshwar hydropower case. Okay, now I had argued that case in Bombay High Court. Okay, where the Bombay High Court restricted the Narmada Bachao Andolan, which was from using certain words. Okay, now that was an interim prayer. When the matter came up for final hearing, okay, which was in a year, for some reason it came up very fast. That time we had argued jurisdiction, because as you know, as I told you earlier in my during the lecture, that it can be filed anywhere where I have read a paper. The defamation case can be filed anywhere. Okay. Now the plaintiff said that they had read the newspaper in. The press conference was taken in somewhere in Madhya Pradesh. They said that they read it here, and therefore they filed the case here. Okay. But when it came for evidence, they forgot to put up anybody to say that I read it here. Okay. So we got it thrown out on the jurisdiction point, saying that the Bombay courts have no jurisdiction. So ultimately that judgment vanished, that Maheshwar, because the main case itself got thrown out. They had the liberty of going back to Madhya Pradesh filing, but they didn't really bother, because by that time whatever they wanted to achieve was achieved. So many of these cases, this is what happens, that they run out of steam after some time. So I have really not seen any case which has really led to a final conclusion of some orders, some compensation being awarded. If you see the law report judgments, you will have some individual cases of earlier times where somebody has sued somebody for defamation, where some 10,000 rupees have been awarded, 20,000, the pre-British period kind of cases. But I have not really seen in the last 20 years, at least since these slap suits began, that any case has led to a situation, I may be wrong, there might be something, but that any case has led to a situation where damages have been actually awarded to in favor of a group this company or that individual. That's the basic. And coming to your first question, the truth as a defense in criminal contempt, okay, did not exist by virtue of interpretation given by the courts for a very long time. Then it was brought in by way of an amendment, sometimes in the late 2000s, the first decade of the late 2000s. Then there was an article which was published in Midday, okay, which was in respect of some judges of Delhi courts. And the matter went to court. And Midday said, we are going to show that what we are saying is correct. But the court interpreted the amendment, because the amendment is slightly loosely drafted, to say that no, even now, truth can't be the defense. You know, that is a situation. Now that has been carried to Supreme Court. It's pending in Supreme Court.
Before we throw it out to the audience, and I'm sure you have several questions, I think one of the you mentioned about a particular lawyer being sued for criminal contempt. This whole concept about contempt, or on the face of it, as they say, and there is this other judgment. Of course, the shoe went past you, but there was also this particular case which somebody did the same thing in the Supreme Court, and it was very interesting. If you read the first, I think the Supreme Court immediately ordered that the person should be arrested and taken away from the court. But the other judge actually said no. Even in these cases, they should be given, principles of natural justice. They must be heard. So I think is that today? I'm not saying that every litigant should throw something at the court, but through now the social media and other ways, is that being viewed from the judicial perspective as do they feel threatened?
Well, possibly, because you see, in newspapers you don't see criticism of individual judges, or you may say criticism of individual judges about the merits of a judgment. Okay, that you may see, but you don't see otherwise any kind of propaganda or something against individual judges by and large. Okay, but on social media, on Facebook and all that, it's quite prevalent. I mean, people nobody has taken notice, or people are ignoring it, or whatever it is. So it's not happening as much as, and it also depends a lot on the judge concerned. You see, because some judges feel that by paying attention to it, you will be giving it more publicity, and it will be worse for the situation. Some judges feel that no, a lesson must be learned by this person, and will send him to jail and things like that. So a lot depends on the individual judge's concern as to how they view. And I'm not talking only about throwing off a chappal or something. I guess most of the judges would view it as a criminal contempt, but other things like a lawyer aggressively arguing something before a court, which is what happened with the particular lawyer who has been was one of the things which happened. Okay? So you have, or there was an earlier case of court proceedings being recorded, and then a dramatized version being put on YouTube. Okay, caricaturing the whole way in which the courts had functioned, and that was treated as contempt. In fact, that is suddenly now come up, and it's coming up this week. And a 5-judge bench has been constituted by Bombay High Court to go into that issue, and it is being defended very staunchly by those lawyers, saying that we have done it, but we have a right to do it, kind of a thing. So it's going to be interesting in terms of its fallout. Okay? But I would say that yes, the judges are sensitive to many of these things, but it also depends a lot on individual judges. Right? Some judges just brush it aside, and some judges really take it on.
Before I hand it over to Sucheta, just one, I think you've very rightly, I personally fought this issue for live streaming, and the fact that you very rightly said, talking about open court and open system. I mean, is that in your view a real sort of issue? I mean, apart from discipline all around, people sitting on time, and the way arguments are done, etc. But do you feel that and of course even from the disability perspective, because how does a deaf person understand what is happening in court? So keeping all that in view, do you think we are moving towards a truly open system?
In terms of what transpires in court, to an extent, yes. What transpires behind the courts, no. Okay, let me put it that way. Okay, but because there is a move now towards at least constitutional bench arguments being televised or being recorded, etc., etc. The judges also feel, this is what they say, that during an interaction which happens in court, many times you start with position A, and after persuasion by the lawyers, you come to position B. So your position itself changes. Okay. Now this is seen by many people as Judge Big Gaya, because it's very easy to make allegations against individual judges also. So that's also because, and lawyers also are party to it. Many times lawyers lose cases and say judge ne paisa khaya. It's very easy to do that. So one can understand the sensitivities. At the same time, I feel that this kind of openness, more and more openness, is something which is needed.
No, thanks. So I wanted to flag a couple of issues before we open the debate, which all of us face, both as activists and journalists. One is the whole cost of litigation business. Okay, so we started out when, defamation cases didn't ask for too much. Then there was a time when we ourselves had at least 4 notices for 100 crores. And it seemed like a benchmark that if you didn't get a defamation notice for 100 crores, that person wasn't even defamed. All these were from companies, okay? We got one from Mukesh Ambani, we got one from Pramod Mittal about how much he spent on his daughter's wedding. None of them went to court until the NSE. Now, Anil Ambani has raised the stakes further. So it's minimum of 1,000 crore that he files, and the highest against NDTV is 10,000 crore. All by Anil Ambani, all about the Rafale deal. Nothing is coming up, right? Now, it's okay to say that eventually you will get justice, but smaller publications like ours, or, the wire services, a lot of them who are there, the whole cost of litigation business has gone out of hand. Because there are 2 things happening. For instance, when Justice Patel granted this 50 lakh, most of it, of course, went to the 2 hospitals. Every single senior lawyer that we met said, oh, it's too much. He shouldn't have ordered so much. Yet, when we went to the division bench, another senior lawyer just stood there and looked at the heavy artillery that NSC had brought, and he calculated what are the fees of the top guys, and he said, this hearing alone is costing the NSC 50 lakhs. Okay? So, large corporates have that kind of money to spend just to harass. And on the other side is a small NGO or a publication where even finding a lawyer who, we were lucky about having someone guide us or appear pro bono, but otherwise it's an impossible cost. And we've also discovered that, again, someone told us that you have to get somebody who has face value. At least someone like you has to be there. Otherwise, even the judges tend to steamroller you. They treat you like you're dirt. They're not even going to listen. So it's all very well for me to say, I will argue my own case. But the judge is not even giving you that respect of making yourself heard, because you're not going to know court procedure and, legal arguments and all that as well. So in this kind of situation, this is on one hand. On the other hand, you have the whole social media where random people can say the most vile, abusive things and get away simply because they are random people, and it's in nobody's interest, neither a large corporate nor the judiciary, to haul them up for contempt. So there is lots of criticism, but when the Justice Karju was putting out blogs, he was hauled up by the Supreme Court, though he had to apologize. But all kinds of very random people, and they think they are very smart that they get away, but they get away precisely because they're non-entities. Would you both talk about this a little bit?
I think one thing which is important is that what Devashish said about journalists being trained about what what is ethical journalism and what can be written, how do you prevent, and if you follow those practices, there are less, it doesn't prevent the possibility of defamation case, but there are less chances of, and I think similar thing about, in fact I was talking to these Narmada Bachao persons that for activists also, because it's all right saying ye chor hai aur isne itna kha gaya aur wo kiya, you know, all those kind of words are used normally in leaflets and pamphlets and all that, but you have to be cautious. You can say similar things but in a language which is more non-defamatory, okay, make the same point but in a language is, so I think it's one thing is also important to be a little trained as to what kind of language one can use. The point which you make is correct, namely that the cost of litigation are prohibitive. Okay. Apart from the cost, it also is just harassment. I mean, you have to set aside your time, which you may fruitfully exercise in something else for doing this, okay? And just spend all your time in trying to work out now how to defend my defamation case, etc., instead of going against somebody else, okay? So the costs are prohibitive, and I don't have an answer to that, a simple answer to that. You have quite a few people who do pro bono work, but the point is that cost of litigation, a cost of a particular litigation are not just costs of lawyers. There is also a lot of costs which are ancillary costs, etc., which are quite prohibitive. And that's the whole idea of a slap suit. Okay, that see, you claim 1,000 crores, you came up with Anil Ambani he has to pay off Mukesh Ambani, he has to repay him for Ericsson and all that. So he'll have to claim that kind of money. But the point is that yes, what you're saying is right. I mean, initial cases, I remember against Maheshwar when they had filed, against Narmada, which they had filed the case, the damages they had claimed were some 2.5 lakhs or something. Okay? That was 20 years back. Now, now, first of all, the benchmark is 1 crore because you want to go to the High Court. Okay? And you can file a case in the High Court only if the monetary claim is more than 1 crore. So you first make the benchmark as 1 crore. And then you demand something which is which is vulgar, 1,000 crores, 100 crores also, things like that. But I don't have an answer to what you are saying, in the sense that how do you deal with it, except various NGOs, etc., coming together, various organizations coming together and having some kind of a meeting, okay, or some kind of interaction whereby at least some kind of common strategy can be worked out. Because just as there are strategic lawsuits against public participation, there should be strategic defense against such lawsuits, and that should be, somehow worked out. That's what I feel.
No, I completely agree that the time has really come. In fact, not only for strategy, but also, a detailed compilation of, judgments today. Because, when you, let's take a case of an individual who has never been to court before. I mean, he's probably watched Suits, so he's watched something else. He's gone there and now he's faced with it. Then what happens? Then, so there is this fear of the unknown. Okay, then he's trying to grapple with so many things. He's probably in a job, and he has to leave all that and then attend regularly, etc. The first question is, can a person actually defend himself? I think there's, in my limited understanding, of course he can. There's, we have classic examples of people on their own. One is sitting here on the first row, Samir Zaveri. He's filed petitions on his own. The other aspect is, when it comes to contempt of court, and especially in the criminal contempt, the worrisome aspect is that no judge looks at it with the same methodology. It's always something which is different. So, for example, I'm just going abroad for a minute. This gentleman was faced with a criminal contempt, a 400-year-old law, when no lawyer in a particular country wanted to even defend him. So then he started looking for a lawyer outside. Now, technically that 400-year law should have gone out of the statute book long time back. And there was no procedure. I mean, he wasn't even allowed truth as a defense. So, and we are talking about this outside of India, not even within India. And I'll never forget this media conference where, many years ago when we went, I'm at that point of time, it was before the amendment came, I found that India had the worst contempt of courts law. Even Pakistan and Bangladesh and Sri Lanka had better laws. So I think we need to do a little bit of catching up there. I think we need to be aware, and it must be much more sort of user friendly. And I think one message that must go out is, please don't, despite the irritation, despite everything else, don't really be too worried about this, because as I think Mihir rightly said, at the end of the day, damages, it fortunately till date hasn't really materialized, but that doesn't mean that you should go over the top.
Just one thing. I just wanted to add one thing to all that, because today we were discussing defamation and contempt of court. And in the context we are talking about activists and journalists facing problems of a certain kind. Remember, there are other laws which are equally and very strongly being used against journalists and activists, whether it's sedition, whether it's UAPA. Okay, so there are a lot of legislations on the law books, okay, which need to be tackled. That's on that. Yes.
Even 66A of the information technology, which is defunct, they're still using it.
Okay, I'm giving it to Krishnaraj Rao. He's, apart from facing litigation, one more thing that he's done recently is a criticism of a judgment which is going around on WhatsApp. And I looked at it and I was thinking, this man has guts, because it's about a judge. Okay, I don't know what has been the consequence, but I'm handing it to you.
Hi. So I would like to basically ask one question here.
I would like to ask you many
questions. Oh yes, of course. I would be happy to share experiences. What you are seeing here is we are sitting in a trio. We are like the trio. We are the defamers of Lodha builders. Yeah. So the proud defamers. Yeah, pardon?
This should have happened long time.
This should have happened a long time back, and we are.
Sign that contract and we sign and we jack ourselves.
Right. So thank God it was Lodha. It could have been some Patel builder or something. In fact, I was sued by a very small builder, 20 crore. For it was not worth fighting. Now here it was really a fight worth fighting. So we are doing that. But a question I want to ask you, and I'm looking for insights on something that I have experienced actually. So I'm seeking some kind of confirmation or some kind of more light on the same matter. My understanding, because I'm 3 defamation suits down. Fortunately or unfortunately, I'm worth about 200 crores currently. Okay, because there is also Ekta World whose case is slowly chugging along in a court in Gurgaon and may reach some kind of settlement. So then there was a 20 crore suit by a nondescript, not a very well-known builder, and then this. My learning from all this is the way it plays out actually in court is very, very, very different from the way it is supposed to be. The intent of the law is one thing. As you said, slap cases are used in a certain way. The most critical part is the ad interim reliefs and the interim reliefs, and so can you give us a little bit of how to deal with that part? I have found that is the part, if you slip up, like in your very first hearing, I'm sharing my this thing and my mistakes actually. I allowed myself to be muzzled in the first hearing and my first thing until the next hearing. And then it went to the next hearing, and then it goes to the next hearing, and then at some point it will enter into, okay, now this case is admitted, and now until the next hearing, which may be several years later. So you essentially are muzzled. You shall write no more on that topic. They cannot ask you to delete it, because for that they would have to prove it's defamation, but you can write no further. And if it is a large builder or if it's a scam where you have lots more to say, then essentially they have achieved their target. So, some of these, how things play out is what I would like to hear from you more.
Yes. I assume what you are saying happened in Bombay High Court.
Yes.
And I assume, I can guess the judge before whom it happened. I guess that. See, the problem is this. Problem is, as I told you earlier, I don't think your decision to begin with was a wrong decision in making a statement that, okay, I will not write anything till the next date. Okay? Because the atmosphere of court is such. The wrong decision in the sense, in your context, it would have been justified, because the atmosphere in court is such that the court is saying that I'll otherwise grant injunction, I'll have to grant injunction, either you agree till the next date or I'll grant injunction, etc. And rather than taking an order against oneself, one would rather make a statement. Okay, so in that context, what you might have done might have been justified in that, and sometimes you don't have a choice. Okay, well, the only choice is that otherwise, if you make a statement, you can't go in appeal. If a court passes an order, because it's your statement, you can't appeal against your own statement. Okay, but if a judge passes an order, then you can go in appeal. Okay. Whether you will succeed or not, it depends on a lot of other factors, including the merits of the case. But at least you have a chance of going in appeal. Okay. But if you make this is the only thing, that if you make a statement, okay, then the chances of appeal go out. And in courts, what happens is that these matters go on and on and on and on. Okay. And then finally, after 3 years, 4 years, it will come up for interim reliefs. Okay. And the court will say, ad interim has been running against you for 4 years. Now let it run during the course of the trial. Why should I hear you now? Okay. And then the case is admitted, and it's admitted in the sense the motion is disposed of by saying that at the time of the suit we'll see what has to be done. Suit will not come up for next 20 years. So that's the broad kind of thing. So therefore, as far as possible, do not make a statement. Because though you may feel at that point of time that it is going to be there only till the next date, be sure, will be after 20 years effectively. Okay, so that's something which you have to be cautious. That's the only thing I can say. Otherwise, you see, it's very difficult to say as to what strategy to adopt. Obviously, you say that if you are confident about what you have written and how you have written, then you can talk about justification. There are times when even before the same judge, okay, if vociferously things are resisted, then he adjourns the matter without passing any order, and then the matter comes up after. Then the other side suffers the same fate. So it can, that the court is very crowded. There are hundreds of people waiting there, etc., etc., and the matters are being done fast. And he has his own views on these matters. See, every judge has his own views. So this is how it works. But I personally think that in these kind of matters, making a statement till the next day doesn't help, because the next day will go on indefinitely. That's what.
If I am not wrong, the lawyers themselves actually are greatly responsible for number of maladies that we face from the court itself. I will say even delayed justice also is because of the lawyers. I should not use the word, but in hand in gloves with each other, kind of the thing. If one party who is losing, and this is a very common experience, that the losing party who keeps on avoiding the appearance even and all that, date after tariq pe tariq, that is their best of the argument. And the other side, from my side, if the lawyer goes on giving them the dates, allows them the itself is my defeat, in the particular case, I can say, of simple of the cases 138, it is a very clear-cut sort of from the beginning itself that you don't have case.
I have a question. Defamation or contempt?
No, in such of the cases, don't you think the lawyers have failed miserably in bringing a real good, say, justice delivery to the society even?
Would you like to react this?
I think you need to see the Supreme Court's one of the latest judgments. They say if you are not satisfied with your lawyer, change him. Very simple. You can do that. So number one. No. So I think there is a whole, there are several factors involved in this. I mean, if you're talking about civil suits, for example, there are supposed to be timelines. Timelines are not met. One of the, I keep coming back to it, that if we don't have legal transcription in our courts, and I say this again and again, that if you had legal transcription, believe you me, you would be able to hold your lawyer responsible for what he said. For example, Tilak's judgment 1908 had transcription. Something has happened between then and now. They forgot about it. Okay. That time you had stenographers taking it down because there was no technology. Today technology is available. So that gives you an immediate insight on what happened in court. Quite often, today you don't even know. The judge whispers something, you can't hear, the lawyer can't hear. It's all, a maze. I think that is one area that if it is implemented, the judgment is there. We really hope, and in fact civil society should support something like this because it will give a lot of clarity, and all these aspects you can actually question your lawyer that, hello, I was not in court, but this is the thing and you did not oppose, why? So I think that probably is technology's answer. For example, very interesting, in Bhutan, Kingdom of Bhutan, if you see the way in which the court, your case is actually presented, there is an Excel sheet. And that is available on the board. So from the date of filing to the date that is, you get in the judge, the lawyer, everyone knows, it was filed in so-and-so, 23 hearings, what has happened? So I think it's more, everything should be on the face. And I think, yes, if people should be a little more responsible. I think that is important.
Lawyers, sir.
So whoever it is, there is a system.
Hello, I'm Anirudh Ganu. I practice in the Bombay High Court and in the civil courts. This is in addition to Krishnaraj's question. You had suggested that, rather than making a statement, he could invite an order. So I was sitting in the court of the same judge which we all know about. I think we know who we are talking about. So this lady advocate who invited an order, she said, my lord, pass an order. He got so angry, he passed an order and he said 50,000 cost. And I don't exactly remember the facts of that case as I heard it, since I was not a counsel in that. But it seems so unfair. So what is the answer to this? On one hand, you make a statement and get stuck for 20 years, a party. On the other hand, you invite an order, and this is the kind of response you get from the bench. I thought it was very unfortunate. I'm an advocate myself, but I felt bad for that party. I mean, is the answer live streaming? So that the judge's conduct and behavior also becomes known to the public? I think a lot of people will be shocked. Is that the answer, or is there some other remedy that you can suggest?
I feel live streaming is one of the answers. Okay. Also, a regular interaction of some kind between, say, the Chief Justice of the Committee of Judges with some representative of litigants or lawyers, okay, is some taking feedback, because just because you are a judge, it doesn't mean that you don't, there is, you can't be wrong, okay. So some kind of feedback, some kind of interaction. People have complaints. People have, some of them might be genuine, some of them may not be genuine, but people have complaints. People have various reservations about functioning of some judges, some this thing. And I don't see, and that's when I say, when I was talking about lack of accountability, that why is it that everybody is living, all judges think they are living in an ivory tower, okay? They should be as much open to criticism as anybody else. We understand that they are under tremendous pressure. We understand that they are working under, they are doing, many of them are doing excellent job. Okay, but at the same time, they have to be, accountable. They have to be responsible, because ultimately, just as they tell us, the lawyers, that the judicial system is not for the lawyers, but it's for the litigants. Similarly, judicial system is not for the judges, it's for the litigants. And so litigant has to be at the center, has to be the central focus of any judicial system. Once one recognizes that, then things can start changing. One can only hope for that.
For the next question, I'm going to make a request. Let's stick to defamation and contempt and not other issues.
I would like to tell you two things, because it was related to defamation as well as contempt, both related. I want to know more detail about contempt but defamation, because if a particular event has been generated and created to create evidence to shield a criminal, will that be counted as defamation? One question. Second one, if a particular judgment has been passed and the person concerned, that is the petitioner, does not follow the order, isn't that contempt of court? Here stands this lady who fought all by herself a case where it's a POCSO case, and in the POCSO case, when the case is filed as per POCSO section 41, I have to keep the confidentiality of the whole situation. I kept the confidentiality of the whole situation, and an FIR is lodged. Debashis sir talked about responsible journalism. The opposite party used the media, the YouTube, and all other possible ways to ensure that this lady does not go ahead, so that she is disoriented and she does not take that FIR seriously. I fought that battle when I was also terminated from the job. Having terminated, so defamation went on there on the news media, on the YouTube, which is still running today, which is still running after having won the case in the tribunal, at the High Court as well as the Supreme Court. Now my question to you, both of you, sir, is defamation is a very difficult task. And I've learned a lot today from Debashis, and I'm ready to move into the defamation state. Because what I look at it is, if we're only thinking of the amount of litigation, we will be allowing people to just go on with anything. And the common man will not be able to place the real issue before the court of law. For me, as an individual who never knew law at all, I did not know ABC of law. But when I was as a respondent in person, at the tribunal as well as in the High Court as well as in the Supreme Court, I learned one thing, that the judiciary as definitely understands if you are standing by truth. And truth has lots of value. So only thing I want to know is this particular thing, creating a situation against a litigant. I mean, now because I'm terminated. And ensuring that particular thing is brought into the session court as well. So isn't that defamation evidence?
It may also amount to criminal contempt, in the sense that if you are trying to create a situation whereby you are making an effort to influence the way the judges will give a judgment. Okay, that may also amount to, forget the defamation would be in case you are whatever allegations are personally made against you would obviously be defamation that one can do, but it may also I'm saying amount to criminal defamation. Okay, that's all I can say.
And the second part, whether not following is a contempt.
Yeah, not following an order of the court is obviously, that's what we call civil contempt. That you're violating an order of the court, and therefore it amounts to civil contempt of court, and that would be contempt.
What is the punishment for that? Contempt of court?
6 months imprisonment maximum.
Sir, I have two queries. One is, if Metropolitan Magistrate has passed the order and party is not complied with, then the same Metropolitan Magistrate has power to compel the party to comply with the order and also impose the penalty to party instead of going to High Court for issue the mandamus writ. Second question is, there are two types. One, the person deliberately that abuse the court and all that, and sometimes during the argument some words coming out from slip of tongue mouth, and judge got unhappy and put him order to for 3 months jail. Okay, so in this section 360 of Criminal Procedure Code, say if person is first time convicted up to charges punishable up to 7 years, then he can be released on probation of good conduct also, no need to put him in jail. So can the Supreme Court that to advocate as entitled right of 360 CRPC? Yeah. And last, sorry, that one gentleman come here. 309 CRPC say there is no adjournment on request of party. So he is saying na tarikh pe tarikh. So he can quote that section and you can help him. Thank you.
Samir has the habit of words coming out.
Sir, for defamation, there is areas, I just want to file a defamation suit against the society. There is areas of 8,000 of the society which is disputed. It is an interest on the interest which society has charged, and I challenge on that to the assistant registrar. And the matter is pending before the assistant registrar from last 2 years. Besides that, society started putting my name on the notice board as a defaulter. So I have taken an objection on that. That is the first issue. And besides that, in the annual report, they are printed against my name as a legal cases that for the explanation of membership, which is there is no 1% point also in the expelling the membership. So in that case, how I can go for the filing a defamation? So that is one. In the same,
Keep it at one question. Because now this
no, it is in the context of the same, in the same defamation suit. There is another.
The issue in general, not personal issues. Would you like to respond?
Take one more and then.
Sir, good evening. I'm Vinod Agarwal. I'd like to one question. Like you are saying some here, if you say something regarding any public servant and Moneylife uploads this in YouTube, so there will be any defamation case against you or the Moneylife?
Against both.
Against both?
Yeah.
Okay. But you are telling the truth, like you are telling about some judges. So, like any public servants, if it is true, then also it will amount to a defamation.
It may not amount to, but whether, see, there are two things. Whether somebody can file a case against you is a different thing, whether you will be convicted or you will be found guilty. Okay. Can somebody file a case? Right now, I can go outside after this meeting is over. I can go to the Shivaji Bagh police station and say that you threatened me with a gun. Okay, the police will have to register it. So, case is filed. Whether I'll be able to prove that you threatened me with a gun is a separate issue. So filing of a case is something which anybody can do. But at the same time, coming back to his question, okay, whether that amounts to defamation, yes. Whether you should file a case, I would tell you avoid filing a case. As far as litigation is concerned, if you are dragged into it, fine. But voluntarily subjecting yourself to litigation is not something which I would advise anybody.
I think what Samir has also raised a very important question. Sometimes where is contempt of court filed? Okay, do you file it in the same court or do you go to the appeal court? So I think that also varies upon a situation. For example, if there is a contempt of the city civil court, you could file it in the city civil court itself, or you can even come to the High Court. The High Court could say that yes, we are, because they have supervisory jurisdiction. So these are important aspects, but always remember the law needs to be checked first, and then you proceed.
Good afternoon, sir. My name is Mahesh, and I am a technical guy, okay? There are lots of technical facts which I feel courts and judiciary misses royally. Like I many times talk about Suchita's case of that in NSE, some brokers, I forget that word. Algo trip. So I come from a networking background. Just like some traders, within short time make too much transactions. And I know many people technically at the back end, they allow it. Legally not allowed, but for some time they allow it and they switch off. So in algo trading, there are algorithms by which algorithms work from a broker terminal has multiple transactions on the NSE bolt. Just 1 second, let me complete it. And there are traces, technical traces as a network layer that I know so much IP these things have caught. But I don't see any legal guy discussing that. Same thing in medical cases. Lots of technique. So the judgment doesn't come correct and the justice is denied or sort of, it's like cheated, simple.
Because the judge doesn't
I don't know. No technical law I'm talking about. Technicality in the presentation of the case. Like आप अगर बीमार हो तो मैं डॉक्टर स्पेशलिस्ट सुपर स्पेशलिस्ट के पास जाता हूँ उसी प्रकार like 2G scam. Yeah, sorry.
Because I think people do appoint amicus when they don't understand, right? But would you like to?
I just wanted to say one thing. As far as judges are concerned, please remember one thing. Internet technology, okay, is 15 to 20 years old. Okay? People become judges after they practice for at least 20-25 years. Okay, so the present batch of judges who are there, if you expect them to know about internet technology and all that, it's apart from 1 or 2 judges, they are not familiar at all with you will have that as time passes. The present, now the new batch of judges would be much more familiar with, would be much more techno-savvy and things like that. So that's one. And even like we were handling some cases concerning a criminal prosecution where the question was whether a computer is hacked or not. Even to get lawyers, okay, who would understand how that hacking is done was very difficult. So so there is a time gap between technology and the human being and the common people, non-technologists catching up with it. So there is some kind of a gap there, and that I guess will be rectified as time goes by.
No, I think you've raised a very important issue. The question is that yes, there is nothing to prevent the court from calling in the expert. I mean, for example, in 2008 when I had argued the now famous abortion case, I knew nothing about the Medical Termination of Pregnancy Act, but the petitioner, the Dr. Datar, he was a practicing gynec and he knew. So what I did, in fact, I mean, just as an example, I did ask him to step into the box and educate the bench. So that I think is again something that the lawyer should do in such cases.
Only one thing, just to add one thing. What happens is you see judges getting experts in matters which they feel they will understand through experts much easily. For instance, if it's a socio-economic situation, okay, say rights of women, rights of children, okay, something like that, then what they do is they call experts, okay, in the field of women, field of children, on disability, etc., etc. and they listen because they feel they are. But when it comes to pure sciences, there is a block. Okay, when it comes to technology, there is many times a block, and that does affect. But I think that is changing now as time goes by.
Experience are mentally just a woman, psychiatrically. The judge told you are not authorized to fight for her. Police के पास जाओ, and police should bring the case. You are a Samaritan, you are a good guy trying to help a लड़की पागल थी, मतलब mentally. I took her to Bandra court, and the judge just didn't listen. I told her, just look at her face. She's in a danger of getting all sorts of abuse. Please take her to mental hospital. And I had a medical certificate from the doctor.
Not defamation. Stick to the point.
My name is Kamlakar Shenoy. I have 7 defamation cases against me and 8 atrocity cases, SC/ST cases against me. All the defamation cases arises from the same incidents and been prosecuted by the different directors, one at Pune, one at Indore, one at... They are making me run around. So what is the solution to this? If at all the incidence is, I have filed a complaint and FIR is registered, and in spite of the FIR being registered, I have made a true statement. So there cannot be defamation. How can the court issue process when there is a FIR registered and it is pending? And what is the remedy to it?
I think you came late. He talked about the Anjali Damania case, but do you want to respond?
No, just quickly that. See, the point is that if cases are filed in different districts of a state, you go to the High Court for clubbing them together and hearing them together. If they are in different jurisdiction, High Court jurisdiction, you have to approach the Supreme Court and say, transfer or club all the cases together and hear them where it is most convenient to me, that is Bombay or wherever you want to. So you can do that, and that is the procedure in law which exists, that you go to the superior court and say, club all the cases and hear them together.
But the other point is there is an FIR, so why this process is being issued? There is an FIR which is justification, so how does defamation come in? That was the other point.
FIR is not conviction.
Yeah, FIR is registered.
FIR is not conviction, and therefore, you see, because you lodge an FIR, right? Because you lodged an FIR doesn't mean that it's that person is convicted. So just as somebody files a case against you doesn't mean you have actually defamed him. That will be decided at the end of the trial. Similarly, lodging an FIR is also doesn't mean that
he has said just because I informed on tweet that FIR is...
Anyway, that's individual. We can discuss it later. Okay.
Last question.
Okay, actually I wanted to add something to what this gentleman said and then what your response was about the technical nature of it. And I wanted to remark also in the context of defamation and YouTube and all those things that have happened. And this is something that judges are finding to their surprise. For example, the normal thing that the judge would, that the plaintiff prays for is, have it deleted. I said you don't have the jurisdiction. You have no jurisdiction to determine whether a US citizen or someone sitting in UK cannot see my video. This was in reference to the material that I had uploaded on YouTube. And I was just playing it by ear, quite honestly. Of course, I had thought about it, but that is more or less what what YouTube also held. So, what has emerged is that because of the technology and because of the way YouTube spans the whole globe, you have a situation where the Indian judiciary cannot actually give a relief to someone who has been defamed, assuming someone has been actually genuinely defamed on, say, YouTube. I believe that unless the person who has uploaded it himself consents to delete it, there is no relief that the judiciary can give as ad interim relief and say, no, you shall delete it. They cannot have it deleted. It will be blocked for India. Of course, those blocks can be circumvented, and there are so many little technological fixes for circumventing the block. I'm just saying that the socio-economic scenario has changed so much along with the technology. The meaning of publishing has changed so much that unless the statute catches up with it and unless the judges educate themselves, they're getting hopelessly out of their depth.
It's an interesting point because I got a defamation notice once from the UK when I was writing for Indian Express, and this is a company called German Capital. While, completely contrary to what you're saying, Indian Express panicked panicked, and they said that the law now means that wherever anyone reads it in the world, they can sue you. And they brought down that article, and I had uploaded it on my website as well. So I said, look, okay, I'm writing for you, you bring it down. I'm not going to bring it down from my website. They didn't pursue the case, so now the article is on my website, and since they didn't, but Express in such a panic had brought it down, it's not on the Express website anymore, and it remains on my website. So this is the position that Express lawyers took, is very contrary. In fact, while they call themselves journalism of courage and how proud they are of hundreds of cases that they defend, they actually were in a big hurry to bring it down themselves, even before this matter went to court, because it never went to court.
The lawyers.
So would you like to?
Actually, I would like to share something else from the perspective of WhatsApp, if I may.
Oh yeah.
See, the understanding of what is publishing and what is publication and what is a private discussion has itself turned into a grey area now. So suppose just to give you an example of what happened to her. The judge had passed injunction against me in the first. It was unjustified and I did not accept it at the moment, and I have continued. But just saying, yes. Yeah, you want me to elaborate on it?
A little bit, because no one will understand otherwise.
I know. Okay, I'll just try to, I'll slightly digress the whole thing. So
Can I actually just answer that, and then if you can, because there is a very important aspect.
Yeah.
Sure. Otherwise I'll forget. Sure. See, and this is a question of actually private international law. What happens is, what if a notice is issued or a summons is issued in an international court? This is constantly, now that the world is getting smaller, both. So if there is a summons there are two aspects. One is that what if you ignore it? Okay, they can issue a subpoena. That subpoena then has to come down, and it has to be filed before a local court, and then they have to decide whether to summon you or not. So I think typically, and my sense is that, when after the World War, what they kind of forgot, and in this space of intellectual property today, especially, where you don't have a world tribunal to hear several of these cases. I mean, today Google, YouTube, all of them are, and once the other problem is, it's like, your sort of rogue satellites or space junk. Once something is in space, you can't actually get it off. I mean, to that extent. Yes, you can block it, you can do so many things, but to pull it off actually is a technological impossibility. So I think these things, must be discussed, debated, and you must have international guidelines. And again, will India actually agree to something like this is an issue to be discussed.
Basically, I know lots of good things are happening in this space. All legal.
Mihir, would you like to?
No, I see what happens normally nowadays is that YouTube, Google, Facebook have regular panel of lawyers, because in all these matters they are joined as defendants. Okay, so they come to the court. Okay, because anybody who files a defamation case, normally it's also something on social media, so they come. And all these people, normally Google and all, they have their own systems that somebody complains, then they take it off, etc., etc. If they find the complaint genuine, etc., etc. So they have that kind of a system, and many times they come to the court and consent. That's what I have seen many times, most of the times. And they say, okay, we will block. If the court says you block this, okay, we'll block it. There are certain things which they can't do. Like YouTube says that we are a platform. We don't generate the content. So we can't do anything about it. It's a platform. Somebody puts it up. That person has to withdraw. That person has you mentioned. That person has to. So these.
The courts have allowed that.
Well, you see, right now we are still at an ad interim kind of a stage. Okay, so possibly in the next year or so, the things will become more clear.
No, it has attained finality actually. On this point, it has attained some measure of finality. So let me explain how it happens. They asked me to delete. They tried to browbeat. In the first hearing, it was essentially a case of full-scale browbeating, where the judge and the very senior counsel, it's an 18 minutes of hearing, and 17 minutes the counsel is on his feet. He is saying they are blackmailers and extortionists and so on and so forth. And after that, the judge just starts dictating the order. Our counsel is not heard. I start going to the counsel and saying, please say something. He tries to make some meek effort. Judge keeps him quiet, and then the order is dictated, and I'm just standing there thunderstruck, stunned. And it is dictated in the order. There is some semblance of give and take, as in they will do some actions, but that was proposed by the judge and agreed by this person, but in no way takes care of our concerns, including our alleged defamation. On the other side, it is said that defendant number 1 and 2 consented to be muzzled, essentially. So that was the way the first hearing happened. At that point, I am thunderstruck. My jaw drops. And only after that, I come out of it, and at night I'd say, I have been muzzled. Now, having been through previous 2 defamation cases and knowing that I shall not be muzzled at any cost, or should not be muzzled at any cost, the third hearing, the third defamation case, when I am muzzled against my will, I just don't take it. I commit contempt of court. I make videos that constitute contempt of court. I said I'll run the gauntlet of contempt of court. So I made some very unparliamentary language wala videos. And next morning I get a notice of motion. Now, the point I am actually trying to come to is, because I was mentioning the case of WhatsApp, and again the ambiguity that technology has created. On one side, excellent. On the other side, what is private and what is public is now clouded in uncertainty. And I would like to point out that. So first I'll clarify about what happens in YouTube, and second I would like to clarify on the clouded situation on WhatsApp. These are 2 different media. I mean, it sounds there's a lot of interweaving between them, but let me just try to be clear on this. On YouTube, I was asked, you delete it. The judge tries to give me an instruction, you delete it. I say, I will not delete it. It has not, you would have to prove to be defamatory, and I had gone into full defiance mode, in the sense that I was willing to, you want to put me in jail, but I am not deleting it. I had gone into that mode because I was not being represented by a counsel. If I was being represented by a counsel, I am sure the counsel would have buckled, and he would have persuaded me to buckle under that. Now, having gone into that mode, the judge then goes, he is helpless. He says, okay, we will make YouTuber respondent. I said, please go ahead. YouTube takes this position. They said, and they cited a case law. They said, we cannot delete the video because he is the owner of the video. If he consents to delete it, then we have nothing to say in the matter. He can delete it. We cannot block it all over the world. He says Supreme Court of Canada had in one case ordered that it should be blocked, but that was challenged later by in a US court, and what was arrived at is only within that jurisdiction it can be blocked. So we can block within that jurisdiction. So what I'm trying to say here is, number 1, Indian High Court has no jurisdiction, which I was also pleading. I said, you don't have any jurisdiction to determine what someone will see in UK or US or anywhere else in the world. Within the borders of the Indian jurisdiction, you can block. That is one thing, and that is what is happening. Now, another thing, let us look at WhatsApp. WhatsApp is a public platform. You can publish to at least 256 members within a group. So you just publish to one group and 256 members can get it potentially. But then WhatsApp can be a very private group between 2 friends. In my case, I have given the example that my family, I have a group. Myself, my wife, my 2 kids. We have a group. if I say something on that group, no matter how defamatory it might be or how contemptuous it might be of the court, it can neither be construed as contempt nor as defamation. I am at liberty to vent within that group. It could be my family circle, I can vent within the group. It can be a friend circle, I can vent within that group. It can be an interest group, I can vent within the group. It is still essentially a private conversation. Now, the reason why this turns out, what happened was that I had been injuncted and I had defied the injunction, but the injunction was against me. Thou shalt not put it on the blog, thou shalt not make any further videos. They somehow interpreted it. There was this very innocuous conversation, I will say it with your permission. There was this very innocuous conversation that she was having where people asked, there's a WhatsApp group of all the building members. So they asked, what is the progress with your case? Everybody is following it. Everyone is a stakeholder. They asked, what's the progress with your case? And she made a very innocuous statement which contained one word, biased, maybe because of the biasedness of the judiciary. It was as vague as that. Somebody from that group snoops, copy-pastes her remark, gives it to the opposite side. Opposite side lawyer produces it before the court, says, look, they are talking about this judgment and look at this term. He underlines and highlights biasedness. Maybe because of the biasedness of the judiciary, what she had said was extremely generic, extremely inoffensive. She was muzzled. Her counsel, so the judge looks at her and, oh, no, how can you say that and all that. And the injunctions that the prayers sought are her defense to be struck off. She should be put into civil prison. These are the kind of injunctions, ridiculous. It completely crosses all limits of this thing. All of that, maybe she was frightened, I don't know. But her counsel says, shall we consent no more posts on the WhatsApp group? And she says, I think she was completely overwhelmed, so she says yes. And she says, can I at least post if someone asks me, can I at least post the High Court's orders on the group? Just post the orders. He says, what is the need? People can come to the High Court website and read it. In other words, no. Essentially, she could not breathe a word on the group. Now, and I went on to make a couple of videos about that. What a ridiculous order. I flayed it with the name of the judge. I said, who made this guy a judge anyway?
What happened to that?
Nothing happened. They the next morning they bring it as with notice of motion, the contempt and all that. And I said, yes, but this is a fact, and I'm going to agitate this matter in the public domain. She still feels muzzled. And मैं तो जंगली घोड़ा हूँ. तुम जेल में डालो ना. जेल में डालना चाह रहे हो डाल दो. जब डालोगे तब डालोगे. अब I have committed so much contempt and I am under that threat of 100 crore. 1 crore would be enough to make me go broke here. 100 crore to डाल दिया अभी क्या? What more can you do? So that's the situation. Law is for law-abiding citizens.
I can't imagine any lawyer
being able to, law is for the law-abiding. Basically, this is what builders do.
It is open hand-in-glove case.
It's open hand-in-glove.
The Lodha and these guys are threatening, and I work with Reliance. It is one day contract sign. He would force you, and I throw back the paper. It's all dramatic. It's all dramatic. No truth in that. But they muzzle the law and force of you because they are big.
I think you're talking to people who practice.
So you seize. I think law is for the law-abiding. And if you show that you are going to be as law-abiding as the builder is, because builder, you bring an order, they will merrily
We will talk about this afterwards because I have a flat in the same building you are talking about.
This gets more and more fun.
So, do you want to respond to this?
But WhatsApp, no, the grey area that has been created is, at what point, for example, in my family group, just to give you an example, can they snoop? Can snooping be permitted? You're talking about law of privacy. How can they snoop in a private group and say committed contempt? What amounts to publication?
There is no snooping because one of the group
members who are voluntarily there, they are the ones giving away the information.
Yes, but it is still a private group. So if my daughter's friend gives away the information,
so I think we are not
about to publication.
This particular case in concern, but as far as WhatsApp groups are concerned, you had instances where the admin has been hauled up, etc. So I think this is still something that is evolving. I think it's not really, but if you, in a given case, if there is a family discussion, and the fact of the matter is Facebook, WhatsApp is all owned by the same company. So let's be clear about that. And in fact, quite often than not, I think it will be very interesting to, Facebook and WhatsApp should actually be sitting here and answering your question. What is the policy on this, and can you just take a particular conversation. Imagine if in fact they were called to court and says, the judge said, I want that conversation. You have it with you. Is it like a telephone call that is it being recorded and things like that? I think all these things need to be gone into. And I think, as Mihir very, very rightly says, a lot of things are happening in the heat of the moment. The law itself on that particular aspect is not, being discussed as it should be, perhaps. And I think that needs to change, from in court. I think that is a very important aspect.
On that note, thank you. We've had a wonderful discussion, and I think we've discussed all aspects of what happens with defamation. In conclusion, I think we should say that lawyers are always going to tell you to take the middle path, because they can't allow you to be reckless, while a Krishnaraj Rao or someone like him or Samir Zaveri can possibly take the stand, can stretch the boundaries, push the envelope, create new things by saying, I don't care if you send me to jail, I'm going to do something. And that sometimes leads to, things being clarified a lot more. Thank you.